With regard to paying insurance, it is necessary that she had employed an attorney, as the original divorce petition ordered Mr. Batchelor to pay medical, health, and dental insurance, vision insurance, and he did not have the children when Miss Batchelor had all 4 children. Was in arrears on his child support, and then later failed to provide health, vision, and medical insurance, and dental insurance. So it was just obvious that Miss Batchelor needed some help, and that she could not really depend on having the Attorney General give her a judgment that would be enforceable for her own benefit. And so it's very necessary for her to employ an attorney. Certainly, the Attorney General's office is a large office as far as personnel is concerned, and as a result of the COVID situation, the Attorney General's hand was full just taking care of their own business, and certainly wouldn't be in a position to advise Miss Batchelor of all the consequences of the legal action concerning the fact that Mr. Batchelor had a history of default, as well as in not only paying child support, but also the medical support, and not obeying the order that was entered in 2018 with regard to the arrearage. Miss Batchelor had no other recourse but to hire a lawyer to have this done. Also, I would also add that Mr. Batchelor didn't make it known that he had another job after he lost his first job. All this needed to be brought out, and Miss Batchelor thought the only way that she could be having it done would be to employ counsel to make sure that it was done, and so that her interests were protected. That's all I have to say.
Thank you, Mr. Schwartz. Mr. Armstrong, would you like to give a brief opening?
Yes, Your Honor. The evidence will show that Mr. Batchelor was ordered to pay child support in the amount of $1,500 per month, and that his medical support obligation was already stopped at 0 prior to us filing this action. And starting on May 1st of 2021, the evidence will show that a temporary order was done, temporarily lowering Mr. Batchelor's child support to $463.39. However, he is behind in payments, and I will present evidence during trial that show what his arrearages are, and I would ask the court to take a judgment for those arrearages against Mr. Batchelor, one for child support, one for medical support, and set monthly payouts for both of those judgments. That's all I have here.
Thank you. Ms. Pierce, you may call your first witness.
Okay, and once again, can Ms. Batchelor be in the screen, Your Honor?
You may.
Mr. Batchelor, can you state your name for the court? You're muted.
Darren Batchelor.
And do you have any other minor children than Brennan?
Yes, I have a daughter that's 9 and a son that's 5.
And are you employed?
Yes,
And did you just hear Ms. Armstrong reference your current child support under a temporary order in this case?
yes,
And is your temporary child support 463.39?
Yes, ma'am.
And was that child support set by Judge Heppard?
Yes, ma'am.
Your Honor, I'd like the court to take judicial notice of index number 47 in the court's file, which is the temporary order.
Any objection, Mr. Schwartz or Ms.
No
Armstrong?
objection.
The court will take judicial
No
notice of the temporary order on file 4/16/21.
And can you tell the court why you got behind on your child support?
Well, I was laid off April, into April 30th, due to COVID. Then I was on unemployment for a good while. Unemployment only took out $300 and something of, I think, a paycheck, which was well, it was twice a month. And then until I got back to work at Columbia Lakes, then it finally kicked back in.
Can I ask you to refer to, I think Respondents Exhibit 1? Can you see that, Mr. Batchelor?
Yeah, hold on, let me get it. Yes,
Okay, and what is Respondents Exhibit 1?
it's a letter from my employer saying when I got laid off.
Your Honor, I'd like to introduce Respondents Exhibit 1 into evidence.
Any objections?
No objection, Your Honor.
No objection.
R1's admitted.
And who was your previous employer?
Forge Drilling Tools,
And how long had you been employed with Forge?
a little over, let's see, 2018, 19, a little over 2 years.
And who had you been employed with prior to that?
Was Fire Rock Energy.
I apologize. Did you say Fire Rock?
Yes, ma'am.
And why did you leave Fire Rock?
I was laid off.
And do
Pretty
you remember when you were laid off?
See, it was so I went to Forge, I believe, in 2018, like March of 2018. So it was 2017. It was like around November of 2017 when I got let
Okay.
go at Fire Rock.
And what is Fire Rock? What industry is that?
It's oil field.
And what was Forge Drilling?
Oil field.
And is that a pretty unpredictable line of business to be in?
Yes, ma'am. It's
Object
up
to
and down.
leading.
Sustained.
So, sir, now what was your child support at the time you were laid off from Forge?
Let's see, it was 1,500 and plus the 135 for the back child support, and then 100 for the insurance.
Okay, and prior to the filing of this lawsuit, did you attempt to lower your child support?
Yes.
Okay, and when did you do that?
That was in September. Actually, before that, but by the time you get a meeting, it was in September.
And were you employed at that time in September of 2020?
No, ma'am. I was on unemployment.
And was the Texas Workforce Commission garnishing your wages?
Yes, ma'am, they were taking out child support.
Did you and Ms. Batchelor attend a child support review with the Attorney General?
Yes, ma'am.
And was that also in September of 2020?
Yes, ma'am.
And would she agree to the reduction of your child support?
No, ma'am.
Did the Attorney General file a motion to confirm arrearages in December of 2020?
Yes,
And as a result of her refusal, did you incur an additional amount of child support in excess of guideline of approximately $6,000 from September to January?
Object to
yes,
leading.
ma'am.
Sustained. Don't lead your witness.
How much money would you have saved if she had agreed in September to lower your child support?
Yes, it would have been that amount,
What amount was that?
the 6,000.
Did the Attorney General's motion plead to confirm all arrearages owed to Ms. Batchelor?
Yes, ma'am.
Did she have to file an enforcement after you cross petition to lower child support?
Yes, ma'am.
She did have to file an enforcement?
Well, it was I don't know, it was a court date that was filed to settle it.
But my question is actually, would she have gotten her arrearages confirmed anyway without filing an enforcement?
Objection.
Oh, yes.
Hold on. What's the objection? Oh, sir, if you hear an
The-
objection, don't answer.
The objection is calls for a conclusion.
Sustained.
Sir, I'd like you to look at Exhibit 2, please. Respondents Exhibit 2.
Okay.
Can you identify that document, please?
This is when they come and got the truck.
Um,
So when they repoed the truck.
I'd like to offer Respondents Exhibit 2 into evidence.
Any objections to R2?
No objection.
No objection.
R2 is admitted.
And was your truck repossessed?
Yes, ma'am.
And why was it repossessed?
I couldn't pay for it no longer.
I'd like for you to look at Exhibit 3. Respondents Exhibit 3, please.
All right, it's loading. Oh, yeah, this is for the house, yeah, this is where I had to. So I had to go ask for help for the house, and they did it, they put it in the mitigation request. And
I'd like to offer Respondents Exhibit 3 into evidence.
Any objections?
No
Uh,
objection.
No, I don't have any objection.
R3 is admitted.
Sorry, Your Honor. I'm sorry, I'm trying to silence my phone. So your truck was repossessed, is that accurate?
yes,
Already
ma'am.
asked and answered.
Sustained.
And your home was your home almost put in foreclosure?
Yes, ma'am.
Already asked and answered.
Sustain.
Are you asking
Object
the
to her
court?
constantly leading the witness.
Sustain. Don't lead your witness, Ms. Pierce.
Thank you. Are you asking the court to retroactively reduce your child support to February 1st, 2021?
Yes, ma'am.
I'd like the court to take judicial notice that the service return for Miss Batchelor was January 12th of 2021.
That's
Are you,
correct. Any
okay, are you
objection
asking?
to that, Mr. Schwartz or Ms. Armstrong?
No objection.
Are you
Mr.
asking? oh, I'm
Any
sorry.
objection to me taking judicial notice of the return of service showing the Ms. Batchelor was served on January 12th of 2021?
No objection.
All right, court will take judicial notice.
Are you asking the court to apply the $463.39 for the months of February, March, and April of 2021?
Yes, ma'am.
Are you asking the court to order a payout on any confirmed arrearages?
Yes, ma'am.
Are you asking the court to deny Ms. Batchelor's request for attorney's fees in this modification due to her refusal to agree to a reduction and subsequent filing of her enforcement?
Yes, ma'am.
Sorry, Your Honor, I gotta check something. Are you asking the court to award you attorney's fees against Ms. Batchelor for forcing this to litigation rather than settling last September?
Yes, ma'am.
I'd like you to look at Exhibit 4, please.
Yes, that's my work contract.
And who is this work contract with?
OD inspections, it's ODI. Field
And-
inspection and hard metal.
And does it say on this document when your contract for employment began?
Yes,
Do you see a date, sir?
Well, yeah, on line 2,
And what's that date?
7/1/21. Oh, that, yeah,
I'd
7/1/21, yeah. Okay.
Okay, I'd like to offer respondents 4 into evidence.
Any objection to R4?
No objection.
No objection.
R4 is admitted.
Now, since this judge did not hear your temporary orders hearing, what job had you been able to secure in December of 20?
I didn't. I was on unemployment. Let's see,
But
wait.
No,
No, I was at Columbia Lake then.
And can you tell the court what Columbia
Started there in
Lake is?
November. It's a subdivision. I was doing maintenance. It's a subdivision and I did maintenance there. I started November the 15th there.
Okay. And you left, did you leave that job to take this job?
No,
Odie?
ma'am. You're talking about which job?
Did you leave Columbia
I
Lakes
was
to
at
take
Forest-
the Odie?
Oh, yes.
And that was a better paying job, was it not?
Yes,
Than Columbia Lakes?
yes, ma'am.
Okay. So I want you to look at Exhibit 5, please.
Monthly child support calculator.
Yes. Can you see where on that exhibit, what does it state as your monthly gross income?
5,000.
And do you see towards the bottom, the second line from the bottom, do you see where it says child support guidelines percentage?
Yes,
And what's that number?
16.
Okay. And what's the projected monthly child support obligation?
624.30.
Okay. I'd like to offer respondents 5 into evidence.
Any objection to R5?
Yes, the objection I'd like to know is what is this $200 for? It says other deductions. What is that?
Well, I'm going to let
That's
you.
my objection is that it hasn't been explained.
All right, I'm going to let you cross-examine on that, but.
All right.
The
Well, Your
Other
objection,
than
Honor,
that,
Okay.
the objection to R5 is overruled. R5 is admitted.
Sorry, let me get back on the screen here. I'd also like you to look at Exhibit 10, Mr. Batchelor.
Yeah, that's pay stub.
Okay, I'd like to offer Exhibit 10 into evidence.
Any objections to R10?
no objection.
No objection.
R10 is admitted.
Now, sir, were you ordered to carry insurance under the original divorce decree?
Yes,
And did you at some point lose your insurance?
yes, I lost it in June. I actually got laid off in April, May, June. They let me carry it till June. That's when I lost it.
Your Honor, I'd like to ask the court to take judicial notice of index number 2, which is the original divorce decree in this case.
Any objection to me taking judicial notice of the divorce decree? Ms. Armstrong?
No objection.
Mr. Schwartz?
No objection.
The court will take judicial notice of the final decree of divorce.
And sir, in that divorce decree, on page 13, is there any requirement of Miss Batchelor if for some reason you lose your insurance?
Was that on the exhibit?
No, I hadn't made that an exhibit. I can,
Okay.
I can come back to that in a minute. If you don't, do you have access to your original divorce decree?
I should have it right here in the cabinet.
Okay,
You want me to grab it right quick?
sure, if you can find it.
All right, I'll get it right quick. Which page was it you said?
13.
All right. Okay, go ahead.
Do you see section F?
Yes, ma'am.
Okay, can you take a minute to read that to yourself?
Yes. Yeah. Yes, I read it.
So if for any reason you lost your insurance, did the original decree order Miss Batchelor to do anything?
Yes, ma'am.
And what did it order her to do?
That if she could get insurance cheaper, that she was to get it and then be reimbursed.
Did she do that?
No, ma'am.
Are you, do you have medical insurance available to you at a reasonable cost?
No, ma'am. I have it available, but it's not a reasonable cost.
I want you to look back at the divorce decree on page 13 under C, definitions, and look at number 2. Is reasonable cost defined in your divorce decree?
Yes, ma'am.
And can you state what reasonable cost is defined as under the divorce decree?
10% of the monthly income.
Are you paraphrasing?
Well, I'm.
Can you
yeah,
just
I'm
read,
reading
can
it.
you just read it, sir? I'm sorry.
Ma'am,
Can you just read what it says instead of paraphrasing?
you want me to read the whole thing on two?
No, just
line
reasonable
two?
cost, just number 2.
Yeah, reasonable cost means that the cost of the health insurance premium is not more than 10% of the insuring party's net monthly income.
Okay, and that doesn't say gross, correct? It says net.
Right.
Are you asking the court to order Miss Batchelor to carry medical and dental insurance on your son if it's offered to her at a reasonable cost?
Yes, ma'am.
Are you willing to reimburse up to the legal limit upon proof that he is actually insured?
Yes, ma'am.
I would like you to look at Exhibit 7, please. Well, actually, before I do that, Your Honor, may I ask the witness to look at State's Exhibit 1?
You may.
I'd like to, may I offer State's Exhibit 1?
Any objection to states one, Ms. Armstrong,
No objection.
Mr. Schwartz?
I don't have States Exhibit 1.
I thought that was the one that we were referencing before we got on the record.
Oh, you mean my Exhibit 1? Yeah.
Now,
No.
hers is actually a newer, but I
I
don't
thought
know.
I sent it to everyone. I can send it to you again, Mr. Schwartz. I thought I sent it to everyone, including the court.
You probably
Let's do
sent it.
this. Hold on one at a time because Minnie's got to take down everything that we're saying. So, and Mr. Batchelor, I'm going to give you that instruction because sometimes you're talking over your lawyer. Make sure you let her finish her question before you start giving your answer because this lady's taking down everything that we say and she can't take down us talking at the same time. We're going to go off the record for right now. Ms. Armstrong, if you'll email Mr. Schwartz that states exhibit number 1 so that he can look at it, and then we'll get back on the record, Mr. Schwartz, after you've had a chance to review it.
Miss Armstrong, if you're going to send it with that Microsoft special code thing, I'll just send it to him.
No, I'm going to send it as an attachment.
Okay, no, I know because it's the when y'all encrypt everything, it's a nightmare. So,
Yeah. I'm doing it. Let me upload it right now.
okay. And oh, actually, so I have it down here, Your Honor, so I can share when it gets admitted.
while we're off the record, well, I'll just wait for Mr. Schwartz's cross.
Okay, and Mr. Schwartz, what is your email address? Make sure I have it right.
It's Don T. Schwartz@gmail.com.
Thank you. I've emailed it to you, Mr. Schwartz.
I think, Your Honor, it's the same as his exhibit, except it's a day newer. Yeah, it's the same as his exhibit 1, but it's a day newer.
Okay, well, let's give him a chance to look at it and then we'll get back on the record.
I just came back undeliverable. Mr. Schwartz, if you could check your email to me if you could do it in the chat. Or Ms. Pierce in the chat box, that way I can make sure it's everything's spelled correctly.
Well, Ms. Pierce, you might just be able to send him it.
Okay,
Okay,
I'll do that because it populates.
on your, okay. Thank you.
Okay, I just sent it.
Thank you, Ms. Pierce.
It meant Schwartz. If you left out the C or something, it might have. With the way my name is spelled, it's always a problem for me. I meant just Pierce. People spell it the other way all the time.
All right, I have it.
Mr. Schwartz, take a chance to look at that. They said it's just one date off from your exhibit, but if you can just verify
We have
that.
no
Or-
objection, Your Honor.
All right, well, let's get back in the record. The court's back in the record in the Batchelor matter. We had just had State's Exhibit number 1 offered into evidence. Ms. Armstrong stated she had no objection. Mr. Schwartz, have you had a chance to review State's Exhibit 1, and do you have any objection?
No objection, Your Honor.
All right, State's 1's admitted.
Your Honor, may I share the screen?
You may.
Okay, Mr. Batchelor, can you see on the screen the child support report?
Ooh.
Can you see
Nah,
this?
Hold on, let me get it.
Okay.
No, it all went off. Hold on.
It's ours.
I gotta get it back. It's work. All right, I see it.
Okay. Can you tell me the date where the cursor is pointing?
7/31/2018.
And does that date reflect that an arrearage was confirmed of 85.20 and 22 cents?
Yes, ma'am.
Okay, and at that point, you were paying 1,900 a month in child support, is that correct?
Yes, ma'am.
So 8,500 literally would be about 4 months of missed support, is that correct?
Yes, ma'am.
Okay.
Objection deleting.
Sustained.
As we look through, would you agree that July of 2018 is about 3 years and 4 months from then to today?
Yes, ma'am.
Okay. And it appears from this record that you were continuously paying your support. Does it not?
Your Honor,
Until-
the exhibit shows for itself.
Overruled. You may answer that, sir.
Yes, it shows that it's been paid.
And the payment numbers drop in June of 2020, is that correct?
Yes, ma'am.
And what happened in June of 2020?
That's, let's see, June of 2020, I was on unemployment.
Okay, so is this,
Are we muted?
March, April, May, June, July, August. Yeah,
okay, so that's what unemployment was withholding.
yeah, what is that, 520? So yeah,
Okay, I want you to look down here on the last page and since in the last 3 years and 4 months, can you look and tell the court how much child support you've paid?
last 71,347.72.
Does that sound like a man who doesn't pay his child support?
ma'am.
Objection.
What's the objection?
Relevance.
Overruled.
Sir, can you look at Exhibit 8, please?
Okay, we're looking at collections.
Yeah, financial information statement.
Yes. Your Honor, I would like to offer Respondents Exhibit 8 into evidence as a shorthand rendition subject to cross.
Any objection to R8?
No objection.
Schwartz?
Yeah, just a minute, I'm looking at it. No objections, but I wouldn't want to, I want to cross them on it.
Sure. R8 is admitted.
Um, Have you incurred attorney's fees in defending the enforcement and bringing this modification, sir?
Yes, ma'am.
Were they necessary to protect the interests of the child and yourself?
Can you repeat that?
Yes, were those attorney's fees necessary to protect the interests of your child and yourself?
Yes, ma'am.
Are you asking for a judgment for attorney's fees?
Yes, ma'am.
Does Ms. Batchelor have a greater ability to pay attorney's fees than you do?
Yes, ma'am.
And why?
Ma'am,
Why do you think that?
well, it's not necessarily the greater ability. It's more like I was pretty much forced into this. It could have been settled in September and wouldn't even have to be going through all this. As far as the child support payment, that's how I feel.
Are you back? Are you recovered from being out of work for 8 months?
Can you repeat that?
Have you financially recovered from being out of work for 8 months?
Oh, no,
Objection,
ma'am.
Your Honor. It calls for, it's vague, calls for a conclusion as far as recover.
Overruled. You can answer that, sir, if you understand it. Sir, the question is, have you financially recovered from your being laid off for 8 months?
Oh, no, ma'am. No, sir. No, sir.
Since Ms. Batchelor's received over $6,000 in excess of guideline child support, are you asking the court to order her to pay your attorney's fees?
Yes, ma'am.
Are you permitted to see Brennan?
Yes.
Do you
I
get
mean-
to see him?
No, no, I don't. It was, that's a long story.
Well, you might want to,
Brennan.
you might want to tell that story.
See, Brennan.
What's that? Ma'am?
You might want to tell that story.
Yeah, so,
Objection,
it was just-
objection, Your Honor. And my objection is if we're going to get into the personal relationship between him and his children, of which he has failed to create, it's going to extend this period. It's going to extend this hearing a long time because there are a lot of reasons why he has not had a relationship with his children.
Your
This
Honor,
is
I
strictly
object to
about money.
talking objection.
All right, sir. Is it, Mr. Schwartz, are you objecting to relevance?
Relevance, yes.
All right, sustained.
Sir, can I get you to look at Exhibit 7, please?
What exhibits are there? These are mine.
yes, request is for relief.
Yes. Now, we're no longer under requested relief. I'd like to offer Respondent 7 into evidence as a shorthand rendition
Any
and
objection?
an aid to
to
the
R-
court.
Any objection to R7 as a shorthand rendition of petition or cross petitioners requested relief?
No objection as long
No
as it's regarded as requested.
Correct. R7's admitted.
Okay, and Mr. Batchelor, we're not asking the court anymore to rule on number 1. Is that correct? That was decided earlier.
Yes, ma'am.
Okay, this requested relief was made in the event there wasn't a bifurcated trial. Is that correct? Sorry,
Yes, ma'am.
bifurcated means that we didn't have 2 separate trials.
Can you
So
repeat that?
I used a word I shouldn't have used. Can I represent to the court that we're not asking the court to rule on number 1 and number 2?
I see that.
And we're not asking the court to rule on number 7. And that is just to make things easier for the court. So, would you agree, sir, with my changes to R7? That's you, Mr. Batchelor. Would you agree to my changes
Yeah.
that I represented to the court for R7?
Yes, ma'am.
Okay, thank you. Oh, and do you believe all the requests you've made are in the best interest of your child?
Yes, ma'am.
And are you asking the court to grant this modification of child support?
Yes, ma'am.
And for all the relief that you requested in your cross petition to modify?
Yes, ma'am.
Okay. At this time, I'll pass the witness and reserve for rebuttal.
Mr. Schwartz?
Yes. Mr. Batzler, you, in April, you agreed as to, that was your signature on that order, right? The temporary orders? Wherein you agreed that
I need,
you would pay $463.39 per month, payable first payment on May 1, is that correct?
Yes,
And now you're asking for the court to change that order and to where your new child support begins on what date?
December 1st.
But you were employed on July 1st, correct?
Your Honor, I'm going to object to this line of questioning for relevance. Mr. Schwartz does not have any pleadings on file to support a change of any child support. So I'm objecting to relevance on this line of questioning.
I'm going to allow it for the limited purpose of the testimony that was proffered that she had been overpaid $6,000. So I understand there's no request to modify it retroactively by Mr. Schwartz, but I'm going to allow the question. Objections overruled. You may answer that, sir.
Can you repeat the question, please?
Yeah,
employed July 1st?
You started your job on July 1st, correct?
Right.
All right. With regard to your financial information sheet,
Okay.
what is your house? What is your house payment?
It's 1,600.
And is that what it's always been?
But yes, sir. It's been lowered since then.
And
That's what
is
my-
that, is it, what kind of house is that? Is it
It's
on, and how much land does that include the house and the land, or what?
Objection, compound
Uh,
question.
What is the $1,600 payment for?
the house.
Is
It's a-
that
it's a
rental
building
or
house.
is that a payment?
That's a payment.
And is that for a house and a lot or a house?
just the house.
Is that what's called a manufactured home or a mobile home?
Yes, sir.
All right. Now you have car payments for $822. What is that for?
That's for the one vehicle we have,
Who is we?
me and my wife.
And you have two children with your present wife?
Yes, sir.
And so this car payment is for this is your wife's car, right?
Pretty much the whole family's, because that's the only one we have.
Well, are you furnished a truck
Yes, sir.
with your employment?
Company truck.
What?
Yes, sir. Yes,
All right.
sir.
What kind of truck is it? What year?
It's a 2017 half-ton Dodge Ram.
And this is furnished to you, is that correct?
Yes, sir.
And that's not
It's a
part of the
company truck.
$5,000 payment, is it?
No, sir.
You get that in additional to the $5,000, right? A month,
The truck, yes.
all right. And you
Yeah.
use that truck for not only coming and going to work, but for your own personal uses too, don't you?
Very little.
Well, you do use it though. It's there for your use, correct?
Yes, sir.
And your gas bill is paid, is that correct? Your automobile gas, your truck, your fuel that you use in the truck?
It's reimbursed.
So when you use your truck for personal use, you're being reimbursed, correct?
No, sir.
Oh, you have separate gas
I
bills
get-
for
I-
for
I put my own gas.
huh?
I put my own gas in it when I use it. I still use my own money to put the gas in it, but I turn in my expenses and then they pay me back.
And they pay you back.
Yes, sir.
And you've got gasoline, oil, bus fares. Is that just gasoline, oil, parking, bus fares? You got a gas bill, fuel bill of $160. Is that correct?
Yes, sir.
I mean, you don't pay any parking, do you?
Every now and then when I go downtown,
Yeah. How often is that?
probably twice a month.
But you're reimbursed for that, correct?
But this gasoline is for our personal vehicle and the oil change.
That's for your own
And-
vehicle, your personal vehicle?
Yes, sir. Because the parking and the bus fares is hurt. I have a stepson that's type 1 diabetic, and we have to go downtown when he gets sick, and that's what that's about.
Okay. And your wife is receiving child support for that child benefit, correct?
Objection relevance?
No, sir.
It's relevant. Hold on. What's the relevance, Mr. Schwartz?
Yes, the relevance is that he's got $160 here, and he's telling us that it's for use of his stepson when his wife is receiving child support.
All right. The
No,
objection-
no.
Hold on. Objection sustained. Next question.
The car repairs, is that for what vehicle?
That's for a personal car.
And then you've got $120, and that's for the pigs you raise, is that correct?
Where you see that at?
It's,
I don't see that.
see, feed for animals, $120. You told us once before that was for hogs that you raise.
Right. Yeah. I have chickens, hogs. Yes, sir.
So you got money for your animals, but not your children, is that correct?
I object. That misstates the
Well,
evidence, and I object to the sidebar.
Or sustain as argumentative. Mr. Schwartz, don't make sidebar comments.
Now that, back to the house payment, they didn't repossess your house, did they?
No, sir.
And the car payment, they repossessed your truck, but you went and bought another car. Is that correct?
No, sir. I didn't go buy another car.
Where's that child? Number. Child support 5. On your exhibit number 5, you have other deductions, $200. What is that for?
Hold on.
I'm sorry, did you say you
exhibit
don't know?
Number 5. No, sir. I'm pulling up. I'm pulling up exhibit number 5. That would be like miscellaneous. The other deductions would be just miscellaneous, like groceries and stuff like that.
All right. Now, you currently have health insurance, is that correct?
No, sir, I don't.
So you don't carry any insurance with your employer?
They have it, but it's so expensive that I can't afford it.
Well, how much is it?
It's like a little over $800 a month, and I get paid twice a week, so that'd be four something a paycheck.
So that's $800 a month for who? Just you or you and your children?
Me and my children and my wife.
So are you saying your children that you had with your present wife don't have any insurance? They're not covered?
The children that I have with my wife now.
Yes,
Is that what you're saying?
yes.
Yeah, no, they're not covered. No, sir, I don't have insurance on them either.
Does your wife have insurance on them?
No, sir.
So are you telling this court that you do not have any health insurance for either you or the children you have with your wife or your other children? Is that what you're telling this court?
That's correct. Yes, sir.
And how do you know, did you get any quotes as to what the insurance coverage would be?
From my employer?
Yes.
Yeah, I mean, they told me that, actually, I think Lisa has a copy of it. Of what it would be.
Have you gone anywhere else to find insurance?
I've looked around some, still pretty expensive.
But you are making car payments of $822. You do have, does your wife work?
She just started.
But you do use your truck for personal uses. That's correct, right?
Every now
Along
and
with
then,
your
yes, sir.
business.
Objection asked and answered.
Sustained.
What is the nature of your job?
Sales, oil field sales.
So you go from place to place. That's what you use the truck for?
Yes, sir.
I have no further questions at this time, Your Honor.
Ms. Armstrong?
Yes, a few questions, Judge. Mr. Batcher, were you ordered to pay child support in this case?
Can you repeat that, ma'am?
Were you ordered to pay child support?
Yes, ma'am.
And did you pay your child support each month as ordered by the court?
When I was working, I did.
Okay. All right. But there are some missed payments since the order began. Is that right?
Yes, ma'am.
Okay.
Yes, ma'am.
At this time, Your Honor, I'd like to enter into evidence I'm sorry, State Exhibit 1 was already admitted into evidence by Ms. Pierce. I'd like to refer to State Exhibit 1. Mr. Batcher, do you agree with me that you were also behind on your medical support payments as well?
Yes, ma'am.
Your Honor, I don't know that he has a copy of States 1. Can I share it so he's not guessing?
If he doesn't have states 1 in front of him, yeah, you can share the screen so he can follow along.
Is that okay, Ms. Armstrong? I'm sorry.
No, absolutely. Thank you. I thought he had a copy. My
No.
apologies.
Are you wanting the last page or are you wanting another page?
This page is fine for now.
Okay.
Thank you. Mr. Batcher, would you agree that as of, let's see, this was printed out on November the 10th. So if we go to the last date in the record, would you agree that you were behind $6,000 for child support?
I'm going to object. The document speaks for itself and it also calls for a legal conclusion.
Overruled.
Mr. Batcher, would you agree that that you were behind your child support in the amount of $6,084.52? As of October 31st, 2021?
Oh, yes, yes.
Okay.
Yes, ma'am.
And then for medical support, as of October 31st, 2021, you were behind $2,332.54. Is that correct?
Yes, ma'am.
Now, you stated earlier that you make $5,000 monthly gross income. Is that right?
Yes,
Oh,
ma'am.
Ms. Pierce, you can stop sharing. Thank you.
Oh,
Appreciate
sorry.
it. Mr. Batchor, was that your testimony? You make 5,000 monthly gross income?
Yes, ma'am.
Okay. And is that rate the same each month?
Yes, ma'am.
Okay. Now, Mr. Batcher, were you also behind on your child support at the end of January, January 31st of 2021?
Yes, ma'am.
Okay. And you were also behind medical support as of that date, January 31st, 2021?
Yes, ma'am.
And the job that you work at now, is this your only source of income?
Yes, ma'am.
I pass this witness.
Ms. Pierce, anything further from this witness?
I'm sorry, I need to get back on the screen. No, Your Honor, but I am going to reserve him for rebuttal.
Any additional questions, Mr. Schwartz, of this witness after Ms. Armstrong's?
Yes, I do, Your Honor.
Go ahead.
Mr. Batsler, you have not paid or contributed any money at all with regard to the bills that Mrs. Batsler has incurred for your son. Is that correct?
Objection to him testifying about documents not admitted into evidence.
Overruled.
Is that correct, Mr. Batsler?
I pay it through child support. They take out $100 a month for that.
Yeah, but you haven't contributed to medical bills that was not paid that Mrs. Batsler has sent you. Is that correct?
I'm going to object that assumes facts not in evidence.
Overruled.
Yes,
Your answer is yes, correct?
yes, yes.
And in
I've
fact, you
paid
got-
some, but I don't have it in front of me what I paid. I haven't paid in a good while, but
well, there was an expense for January 28, 2019 of $60. Ms. Batsler paid $60, sent you a certified letter, and you didn't respond by paying $30. Isn't that correct?
yes,
And then on February 5th, 2019, Ms. Batsler incurred a bill of $162.37. And she sent you a bill for $81.19. You didn't pay that either, did you?
not personally, no, not, I didn't write her a check, but like I said, they take out $100 a month for medical.
And then February 12th, 2019, she paid the $60 for medical for Brennan, and you didn't pay the $30. Isn't that correct?
Correct.
Same thing for March 1, 2019. There was $155.55 bill, and you didn't remit half of that to Miss Batsler, did you?
No, sir.
And on May 15, 2019, a $40.97 bill was incurred, and you didn't pay half of that either, did you?
No, sir.
And there was another bill for $7.08, and you didn't pay half of that, correct?
Correct.
And then August 20, 2019, a $50 bill was incurred, and you didn't pay the $25 on that, did you?
No, sir.
And then on June 3, 2020, a $183 bill was incurred, and you didn't pay $91.50. Is that correct?
That's correct.
Then on June 10, 2020, $95.38 bill was incurred, and you didn't pay the half of that. You didn't remit half of that. Is that correct?
Correct.
And then on May 19, 2020, a $9.49 bill was incurred, and you didn't pay half of that, $4.75, did you?
No, sir.
And you received notices to pay these bills, didn't you?
Some of them.
And in fact, August 3rd, there was a 183 bill of 2021, and you didn't pay that either, did you?
I believe that's
No, sir.
cumulative, Your Honor. I'm going to object.
Overruled.
And then on August 17, 2020, 21, and August 3, 2021, you were sent bills, and you didn't pay half of that either, did you?
No, sir.
And in fact, you were also received 2 bills later this month, and you didn't even open them up. Isn't that correct?
Objection calls for speculation.
Overruled.
I have no idea about those.
Well, they were sent to your office by certified mail or your house, and you refused to take the mail. Isn't that right?
No, I never did refuse.
I have no further questions at this time, subject to whatever.
Ms. Armstrong, any
Additional.
additional questions?
No additional questions for this
Speak.
witness.
Ms. Pierce, anything further from this witness at this time?
No, I just reserve for rebuttal if I need him.
Okay, Ms. Pierce, you may call your next witness.
I'd like to call Amy Batchelor.
All right, Ms. Batchelor, you're being called as an adverse witness. What that means is Ms. Pierce is going to be allowed to ask you leading questions that may call for a yes or no response or a very short response. Your lawyer is going to get an opportunity to question you when she's done. So if he feels like you need to explain an answer, he's going to give you an opportunity to do that. Right now, I need you to just listen carefully to Ms. Pierce's questions and only answer the question that's asked. Don't volunteer more information. Just wait for Mr. Schwartz to do that with you. All right, you may proceed, Ms. Pierce.
Thank you. Can you state your name for the court?
Amy Batchelor.
And did you attend a child support review with the Attorney General in September of 2020?
From what I remember, it was an enforcement because I'm the one that reached out to them. So I can't say what.
Well, where did you attend this enforcement?
Zoom.
And there was a judge present?
No, it was Attorney General.
Okay. At that meeting, did they provide you evidence that he was on unemployment at that time?
I don't even remember them saying that. We talked about arrears at the time. And then at the very end of the meeting, they threw in a modification just at the last minute. And I didn't know what to do about that.
Is it true that you refused to agree to a reduction in child support?
At that moment, of course, yes.
Did you used to work for Mr. Schwartz?
I sure did.
For how long?
4 years.
And how much money have you paid to Mr. Schwartz to represent you?
How much money did I pay him?
Or have you paid him to represent you? in
Not
this
yet,
case?
because Not yet. We're waiting on all of this to end.
Okay, so you haven't paid anything to this date.
Correct.
Okay, do you have a contract with him?
So a contract? No, we don't have a contract. He trusts me to pay him.
I'd like to, at this time, Your Honor, I'd like to offer, I don't know what it's, Don, what are your exhibits called? Are they also called respondent or what are they called?
I just call them exhibits.
Exhibit 5, which I believe is your financial information statement. I'm sorry, I'm trying to find the exhibit. I'd like to offer Mr. Schwartz Exhibit 5 into evidence.
Any objection to Mr. Schwartz's Exhibit 5?
No objection.
Mr. Schwartz?
Yeah, I've got two changes that should have been made that weren't. One, she doesn't have boat or an insurance that was sold.
Well, Your Honor, he can clear that up. I'm just asking to get it admitted at this time.
Other than the fact that there's a couple of changes that need to be made to it, Mr. Schwartz, any other objections to your Exhibit
No.
5?
No objection.
All right, Exhibit 5 is admitted.
Ms. Batchelor, I noticed on your, do you have a copy of your exhibit in front of you?
Yes.
I noticed you have insurance premiums of $917. What does
Mhm.
that insurance cover?
Vehicles. Mine and my children's.
How many vehicles is that?
3. Actually 4, I think, on that. It's 3 of my kids and mine.
I notice over here under legal fees, it's blank.
Right, because I hadn't paid him anything yet.
Um,
We're waiting until it's all finished.
So, are you aware in your divorce decree that if he was uninsured, that you were ordered to obtain insurance for your child?
Since you said that today, I heard that.
Okay, so would it be accurate to state you didn't do that?
I have insurance currently.
You have medical insurance?
Yes. I just got
Or-
it a couple months ago.
And have you brought anything to the court today to show what that insurance is? And
No, haven't.
um, and how many people are on the insurance?
3.
And who are those?
My 2 sons and I.
Okay, and one of your sons is an adult in that group?
Yes, 20. He's in college.
And who is that insurance through?
It's Melina.
Can you explain to the court why you didn't file your enforcement until after I entered the lawsuit?
I have no idea. I couldn't even give you an answer on that because that was not my intention.
Okay. So you weren't retaliating against him for trying to lower his child support?
Absolutely not. Why would I do something like that?
Were you hoping to get attorney's fees in an enforcement as well?
Was I hoping to what?
Get attorney's fees in an enforcement as well?
I mean, I assume so, since I'm having to do the enforcement because he cannot pay what he's supposed to pay or chooses not to.
Ma'am, are you aware that since your divorce, he's paid over $300,000 in child support?
And how's that relevant? How's
Oh,
that
man.
relevant?
Hold on, ma'am. Your lawyer will object if there's an objection. You need to just answer questions right now. Are you aware that that's what he's paid?
No, I'm not.
So the Attorney General was going to confirm any arrearages at no cost to you. Is that correct?
We already know how much the arrears are. I don't know.
And, but you wanted Mr. Batchelor to pay even more, didn't you?
Pay even more of what?
Just anything, any more money.
No, no more than what he rightfully owes.
And what would that be?
The amount that's on our sheet from the
I'm
Attorney
sorry.
General and what he owes me from since 2019, January 2019 and forward that he hasn't touched. I'm not asking for a dime over what he owes.
I sent your attorney discovery on September 12th of 2021. Why didn't you answer that?
I don't even know what you're talking about.
Do you own any interest in trusts?
Trust?
Mhm.
No.
Did you, what did you inherit from Dorothy Rector?
What, stocks or what?
Uh,
I mean, what
yeah.
are you talking about?
What did you inherit from Dorothy Rector?
What did his wife inherit from her grandfather dying?
No. Ms. Batchelor,
Objection to relevance, Your Honor.
sustained to that, sustained, but ma'am, hold on. Ms. Batchelor, you need to just answer the question that's asked. Quit asking questions of the lawyer. It's not appropriate. Just, your lawyer will object when there's needs to be an objection. If he doesn't, then you just need to answer the question. The objection to relevance is sustained. Next question.
Well, Your Honor, I pled for attorney's fees. I sent.
I understand that, but we're not going to get into what she inherited for purposes of today. Objection sustained.
Have you told your sons that Mr. Batchelor doesn't pay any child support?
No,
Okay, so
they
if
know what he does.
so if they've said that, then they would be lying.
If what? My kids
they-
they're not in the habit of lying.
And
They know when he pays and when he doesn't. They're old enough to know.
are you angry that he no longer works in the oil field?
I don't care where he works. I have no feeling about that whatsoever. Why would I be angry at that?
Don't
It
ask
doesn't make
questions.
sense. I'm asking you.
Do not.
I'll pass this witness.
All right, Mr. Schwartz, do you have questions of this witness?
Yes. Have you sent him by certified mail the medical support that I've outlined that is Exhibit 2 to my pleading?
Yes.
And has he paid any of that?
No.
Now, I did just now notice that the total expense here on May 19th, or no, let's see, no, August 3, 2021 is 183, and that they got 183 twice here. Is
Your
that,
Honor, I'm going to object to relevance. He
No,
has no
sure.
pleadings on file to support this.
Your Honor, I'm merely trying to explain that what appears to be a discrepancy as to what,
It's because he didn't have insurance.
I'm-
It was 100%.
I don't see I see the 183. I don't see it on here twice. I just see that she's asking for 100%, not 50%.
all right, okay, all right. That's right. That is 100%. You're right, you're right.
Your Honor, if I may, what is the court referring to? Nothing's been entered into evidence.
exhibit number 2.
That has not been admitted.
Well, that's one of my exhibits and I'll offer it.
All right, you offering exhibit 2 at this time?
Yes, I am. It's
I
need
part
to
of my
object.
pleadings also.
And I'm
Understand.
objecting, it is not supported by his pleadings, and I'm objecting to relevance.
Response, Mr. Schwartz?
Yes, these are medical. When I'll restart this questioning.
Well, no, I
Ms.
don't
Bat-
need, hold on. I'm following the questioning. I'm just asking, she's saying that it's not relevant because there's no pleading to support your requesting these, and I need a response to that.
Sure.
argument.
On paragraph, on my second page of my pleading,
I believe he's
says,
referring, Your Honor, to his enforcement, which has been dealt with.
no, but this, my pleadings are not only for enforcement. I'm also asking for a judgment.
Right, and
in-
I
in
said
my
we were gonna
pleading.
deal with it, hold on. I said that we were gonna deal with the judgment as part of the modification, because I couldn't deal with the judgment because I had to deal with a retroactive request that the child support be reduced retroactively. So we are dealing with still the enforcement from the standpoint of he's asking for a judgment for the arrearage. So the objection to relevance is overruled. You may continue, Mr. Schwartz.
But Your Honor, the enforcement trial is closed.
Except for the fact that I said the confirmation of the arrearage we were going to deal with in the modification, because he's got a request for that in the enforcement. And I said prior to us closing on that testimony and enforcement, we were going to deal with the confirmation once we got Ms. Armstrong in, because we couldn't deal with that without dealing with your request to retroactively reduce his child support. So I couldn't do both. I'm not going to harm him by allowing you to have a bifurcated trial and not let him ask for a confirmation of the correct amount of arrearages. So Mr. Schwartz, you may continue.
Yes. With regard to the medical support that wherein you submitted bills to Mr. Batchelor, is he in the arrearage in the amount of $773.94?
Yes,
And is that the same $773.94 that is in Exhibit 2 of our petition?
yes,
So in addition to the arrearage of this amount right here of $2,332.54, he owes an additional amount of $773.94. Is that correct?
Objection,
Yes.
that calls for a legal conclusion.
Overruled.
And if you add the two, that adds to $3,106.48. Is that correct?
yes,
And here again, those figures are also stated in the exhibit number 1 to my pleadings, where it states that medical support in arrearage is the sum of $2,332.54, right?
yes,
And then if you add up on exhibit 2, these figures of that we've gone over January 28, 2019 through August 17, 2021, that Mr. Batchelor agreed he hadn't paid, that sum is $773.94, correct?
yes,
So you're asking for the arrearage to be the sum of $3,106.48. Is that right?
yes,
And then your figure is what the Attorney General says
Objection
on
leading.
page exhibit 1.
Hold on. Objection leading sustained. Don't lead your witness.
All right. What is the sum of $6,225.58?
what is it for?
Yes.
Child support arrears.
And is that the same figure that was given to you by the Attorney General,
Yes,
which is in the pleadings? Is that correct?
yes,
And You're asking that the child support be paid retroactive to July 1. Is that correct?
Objection. It's not relevant. He has no pleadings to support that.
Response,
not
Mr. Schwartz? Mr. Schwartz, do you have any pleading for that?
I believe I do, Your Honor. Let me look.
If you can direct me to that, please.
He filed an answer on March 12th, Your Honor.
Yeah. Move-in is requesting that the amount of child support be increased to respondents' present earnings and be retroactive July 2021. And that's on the third page of my pleading. It's paragraph 14.
Your Honor, that's not appropriate in an enforcement to request a modification. And that's what he's referring to. Is
Yeah,
number-
so that's in your third amended motion for enforcement. Is that correct, Mr. Schwartz?
Well, it's not only a petition for enforcement, it's also for a petition asking for judgment and for child support to be retroactive. My pleadings request for arrearage, interest, and then my pleadings also request that the amount of child support, that's paragraph 14 in my pleadings, is requesting that the amount of child support be increased to respondents' present earnings and be retroactive to July 2021. And I'm saying increased from the April order. The court entered an order in April of paying $463.39 a month. And I'm asking that the child support be increased to reflect his present earnings and that it be retroactive to July 2021. The heading does not control what the pleadings say. And that's what Mrs. Pierce is arguing. She's just saying this is just a motion for enforcement. The pleadings specifically state what we're requesting.
Yeah, the court's gonna, I'm familiar, I mean, I've looked at your pleading and it is, I understand the objection that it's in a motion for enforcement and not in a counter petition to modify. But the court's gonna overrule the objection. You may continue, Mr. Schwartz.
So in essence, Ms. Batchelor, inform the court what you want this judge to do or what you think is in the best interest of the child.
Child support arrears.
As
Be paid.
I'm sorry, Your Honor, I've been frozen, I guess. Were y'all working?
Oh, did you not hear that?
No, I didn't hear it. I just realized that y'all all stopped moving.
Okay, where did we leave off, Ms. Pierce?
I'll
Right
restate.
after you ruled on my objection, that's when it ruled, that's,
Oh, okay, you got that. So then, Mr. Schwartz, you may continue. He was on his.
Absolutely. I'll just restate the question, Your Honor. Ms. Batchelor, what are you requesting that would be for this court to order that would be in the best interest of Brendan?
To Brennan, the child support and medical arrears and all of the medical expenses that I've incurred that he's not paid, and insurance for Brennan,
And insurance for Brendan. So,
medical, dental, and vision.
and so what you want to do is you want the additional $773. Is that right?
objection leading.
Overruled. I'm gonna allow it
Well,
because he's
I mean,
talking
I
about
already said it.
requested relief, so I'll
Okay.
Yeah,
allow
I
lead
said
in that.
That was included in what I said. The child support and medical arrears plus the amount that he owes, that I've sent him letters that he's ignored. And then insurance for Brennan, medical, dental, and vision, and attorney fees.
And you have employed me, is that correct?
Yes.
And you agreed to pay me, is that
Of
correct?
course, yes.
And Your Honor, we would ask the court to admit Exhibit 1 and 2, which are the Attorney General of Texas Child Support Division records.
All right, to Ms. Pierce, I got your objection to Exhibit 2. Ms. Armstrong, any objection other than Ms. Pierce's objection, or do you have any objection to Exhibit 2, Ms. Armstrong?
No, no objection.
Either one of you have an objection to Exhibit 1, Ms. Pierce or Ms. Armstrong?
I just object. It's cumulative. It's the same as states one, except a day older.
All right, the objections to Exhibit 1 and 2 are overruled. Exhibit 1 and 2 are admitted.
All right, Ms. Batchelor, Exhibit 3, which is the extra medical that you incurred. Does Exhibit 3, are all those the ones that are listed on Exhibit number 2?
Yes. That's the letters and receipts.
So these are bills, these are not only the bills, but they're also copies of the receipts that you paid, right?
Yes. correct.
Objection leading.
We would
Sustained.
ask that Exhibit 3 be admitted, Your Honor.
Any objection to Exhibit 3?
No objection.
No objection.
Exhibit 3 is admitted.
Exhibit number 4, I would submit that with the exception that the hearing is more than 2 hours and it's more like 5 hours. And I would request the court to admit Exhibit number 4.
Any objection to Exhibit 4?
Yes, I object because I don't know if I don't know if he's going to call himself and I need some. Well, okay, I'll admit it and I'll cross her on it, I guess.
Ms. Armstrong, any
Yeah.
objection to Exhibit 4?
No objection.
Exhibit 4 is admitted.
All right, I have no further questions of Ms. Batchelor.
All right, Ms. Armstrong, you tend to be going pretty quickly. I thought I'd finish with your direct and then we're going to take an afternoon break, let the court reporter rest her hands. How long do you anticipate with this witness, Ms. Armstrong?
Just have a few questions.
All right, let's go ahead and
Shouldn't
do
take
that.
long. Ms. Batchelor, you stated that you do have private health insurance available at this time. Is that right?
Right.
Is it through
Yeah.
your employer?
No,
Who is it through?
Molina Healthcare.
I mean, is it, you just went to the market and got it? It's through another
Yes,
source?
market.
Put in your
market.
name? Okay. And what is the cost for that plan?
The cost right now is 0 until the end of the year. And then when I do my taxes, they see how much I made. Household income, they include my son as well. my 20-year-old. And the way they do it is if you estimate incorrectly your annual income, then they make you pay it back.
Okay, okay.
But starting
as
in
of right now,
January-
it's zero, correct?
That's right.
And when did you obtain that insurance?
It was probably 2 months ago.
And how many people are on that plan?
3.
And you do acknowledge that Mr. Batcher is behind on his child support, is that right?
Yes.
And you do acknowledge he also has a medical support arrears, is that right?
Yes.
Okay, I pass the witness, Judge.
All right, we're gonna go ahead and break for our afternoon break. Let's resume at 3:45. The court's in recess until 3:45. We'll get it to you. All right, the court's back on the record in the Batchelor matter. Ms. Pierce, you have Ms. Batchelor as an adverse witness. If you have any additional questions, you may ask your questions at this time.
Yes, Your Honor, thank you. Ms. Batchelor, can you look at Exhibit 4?
Okay.
If you look at 32621, what's recorded next to that entry?
What does it say? Office conference and all that? Is that what you're asking?
Yes. Mhm.
Office conference and with client in preparation of motion for enforcement of child support order and order to appear and review of attorneys general pleadings, attorney general pleadings.
And how much was that entry?
2.25 hours.
Okay, and that looks like it refers to the enforcement. Your Honor, I object to counsel speaking with her while she's testifying.
Yeah, Mr. Schwartz, make sure you're not saying anything to her while she's on the stand.
I was just pointing to her.
Yeah.
Well, that too.
Yeah, let's let her testify from her memory. If you have an issue with something she says, you're going to get a chance to question her again, but she needs to testify without any help at this time. All right, you may continue, Ms. Pierce.
Would you look at 519 and tell me what's next to that?
Preparation of amended pleading and filing. Half hour.
That would also relate to the enforcement, would it not?
I
The
don't-
witness appears to be looking. while
No, I don't
Mr.
even know.
Schwartz appears to
Honestly,
be
I don't know
writing.
what it is. I personally didn't make the bill, so I don't know what these are for, and I only see what it says.
On 6/1/21, it states process service fee of $125. Was that to serve Mr. Batchelor with the enforcement?
I don't know what it was for. It was to service him of something.
So you don't know if these charges are reasonable or necessary, do you?
Everything on here should be on here, if that's what you're asking.
No, that's not what I asked.
What are you
I-
asking?
You don't know, then you have no way to know if these are reasonable and necessary charges since you don't know what's on here.
Sure they are. Yes, they are.
So then you do understand this document and can testify
Well,
about it.
I can understand that I've been here many hours and that I owe him money for it, spending hours of his time.
It looks like your attorney likes to charge in 2-hour increments mostly. Would you agree with that?
I don't know what he likes to charge for. I know that when I'm here, it's usually about that much time, minimum, usually 2 or 3 hours.
And now it looks like 9/1 was a 2.15-hour meeting where he looks like he reviewed the petition of the Attorney General for the 3rd time. Is that accurate? You see on 3/12, he reviewed pleadings. On 3/26, he had to review them again. 9/1, he reviewed them again. Do you see that?
Mhm.
You stated that your Molina policy was based on your estimated income. What is your estimated annual income?
Well, last year, that's where they got this one from. So we went off of the tax return of 2020.
Okay, then would you like to tell me what your adjusted gross income of 2020 was?
Would I like to?
Yes.
Yeah, so the amount on my tax return is 23,000.
And what about dividends, capital gains?
None.
Do you believe you're going to be able to get the same cost of the insurance next year?
I know I'm not. They've already told me I'm not. Last week.
Okay. I'll pass this witness.
All right, Mr. Schwartz,
I have no further questions of this client.
Ms. Armstrong,
I have no further questions.
Ms. Pierce, you may call your next witness.
Your Honor, I'd like to call myself.
You may testify from the narrative. Did the
Thank
lawyer
you.
stipulate to her qualifications?
I'll stipulate, yes, Your Honor.
Yes,
Court will accept that stipulation. You may proceed, Ms. Pierce.
This is, well, my rate is $250 an hour, and Darren Batchelor needed representation to protect the best interests of him and his child. My fees spent for researching, preparing pleadings, meeting with the client, discussing litigation, hearings, are reflected in Exhibit 9. Your Honor, I'd like to offer Respondent's Exhibit 9, since it was actually introduced in the other hearing, not this hearing.
Any objection to R9?
No objection.
no objection.
R9's admitted.
Thank you, Your Honor. My clients incurred $78.20 in costs for filing fees. I have spent 23 and a half hours prior to today. And we started at 10:30. Is that right, Your Honor? 10:30 to 12 was 1.5 and 4 hours today. I'm asking for a judgment for attorney's fees in the amount of, I got to add, sorry, Your Honor. $6,375 plus costs. I ask that the court award that to me as a judgment in favor of me with interest and ordered paid directly to me. These were both reasonable and necessary and are customary. And with that, I will pass myself.
Mr. Schwartz, any questions of this witness?
Yes, Ms. Pierce, you would agree that we have had several Zoom hearings without accomplishing much just because of schedules of the judge, of the court. Is that correct?
I agree. We had a setting on 6/2 that the AG was not ready to go forward. We had a setting, your enforcement setting of 7/7, which you opted not to go forward. I believe we had another one in September. I'm trying to remember now. And all those, of course, were Zoom. We were in our office. We could keep working while we waited, and we did not go forward on those settings. I would agree with that. Matter of fact, if you look at my bill, I don't even record the June 2nd setting. I don't bill for it at all.
I have no further questions of this witness, Your Honor.
Ms. Armstrong,
No questions, Judge.
Ms. Pierce, any redirect?
I don't, I guess at this time I rest, and I don't know if we're, if, I don't know if we're now going, oh, no, I don't. Actually, hold on a second. I can't redirect. It's her case.
No, redirect of yourself as a witness.
Oh. No, I don't. I don't believe I have any redirect of myself, Your Honor.
Okay, any other witnesses you'd like to call, Ms. Pierce?
No, I'm fresh out of witnesses, Your Honor.
Cross petitioner rest. All right, at this time, Mr. Schwartz, any witnesses that you'd like to call on your case in chief?
Yes, I'd call myself as attorney.
All right, you may testify from the narrative. Can we stipulate to his qualifications, Ms. Pierce?
Yes.
Ms.
Yes.
Armstrong? All right,
Yes.
Mr. Schwartz, the court will accept those stipulations and you may proceed.
Yes, I would like to, if I have, I think I've admitted exhibit number 4.
Yeah.
And what I'd like to do is I would like to add, I had 2 hours for today's hearing. And what I'd like to add is 3 more hours to that, which would be another 1,050 at $3.50 an hour, which would make the bill $7,790. Although my pleadings were headed or the title, however you want to put it, enforcement. I was also, it was very important to my client that we make sure that Mrs. Batchelor was being properly represented as far as determining child support, the amount, and to see what we could do about getting the prior orders enforced, collected, and determined. That is the proper amount that the Mr. Batchelor was in arrears. And unfortunately, we did have a couple of hearings where our appearances that we didn't get anything really accomplished, but we did reach an agreement, which was reflected in the April 2021 temporary order. And as you know, having been a private practice, there's time spent for preparation. Maybe some of it might be duplicitous, but it's still important to make sure that you do your very best. And so some of my hours reflect that I was with my client. We were going over the material, making sure that it was correct. And then there's explanations that need to be made to the client. And so my total hours that I'm submitting is 21 hours and 21.9 hours. And I did incur $125 expense to have Mr. Batchelor served because Mrs. Pierce would not accept service and requested that I have him served. And that is the
Objection,
purpose of incurring the $125. I'll pass the witness.
Ms. Pierce, questions of this witness?
Sure. What increments do you bill in, sir?
10 minute. And quarterly.
Looks like 9.2 hours of your bill, well, no, including today, would be 11 hours of your bill are for an enforcement.
I
And
wouldn't say, I can't divide it up before enforcement. Most of this, in fact, just about all of the time was spent on the math and trying to get to figure out, to make sure that the proper amount was afforded. Mr. Batchelor had several jobs, and we had to find out just how much he was getting paid, and it was discovery and trying to obtain a figure of the amount of child support in arrearage, as well as to determine what the child support should be.
my office provided all those documents to you. Would that be accurate?
Yes, you did. You finally did. Yes.
And you stated we came to agreements in April. Sir, do you not remember that that was a contested hearing, that the judge ordered all the relief requested in that?
Well, she did, but there was some agreement to it. I can't figure out. I don't remember just exactly, but we did agree on several of the matters.
Okay, forgive me for not remembering what we agreed on. And although you had no active modification, it took you 21 hours of work to prepare for this modification. Is that accurate?
Well,
I'll withdraw that. I'll withdraw that question. Included in these bills are 3 separate amendments of an enforcement. Is that correct?
Well, yes, yes, there was.
And
I am merely to bring my pleadings current.
didn't I actually tell you that I couldn't accept service for my client as I had not been retained to represent him on an enforcement?
You had told me that you could not accept my pleadings. And yeah, you said you weren't, but I mean, if that's the case, well then but you were representing him, and you were representing him in several matters. And so what you did is you just said, well, I'm going to make Schwartz pay another $125 if he's going to go forward with it. You knew you were representing him, and you knew you were going to represent him in the future. And you had to go through this step.
Sustained. Next question, Ms. Pierce.
So, I'll pass this witness, Your Honor.
Ms. Armstrong?
No questions for this witness.
All right, any redirect of yourself, Mr. Schwartz?
No.
All right, Mr. Schwartz, you may call your next witness.
I arrest, Your Honor.
All right, Ms. Armstrong, any witnesses that you'd like to call in your case in chief?
No, Your Honor, I believe I covered my questions during the other case in chief. Thank you.
All right, and Ms. Pierce, any rebuttal witnesses that you'd like to call?
No, Your Honor.
All right, the court, I do have a question, and it's for Ms. Batchelor, and I'm going to let each lawyer ask questions if you have any questions after my questions. But Ms. Batchelor, looking at Exhibit 2, your Exhibit 2, Mr. Schwartz, if you can pull that up for her.
Yeah.
Ms. Batchelor, the last 3 entries on your medical expense itemization sheet, Exhibit 2, show that Mr. Batchelor should pay 100% of those uninsured medical costs, and everything else is 50%. So if you can tell me why the difference, why you did 100% on these last 3 entries.
Yes, because on the decree,
Judge,
it
I'm
states
sorry,
that he is
Miss
not
Every-
able to
Hold on,
I
Ms.
missed-
Batchelor.
She talked.
I'm sorry, I was frozen. I didn't hear anything after you asked her to look at Exhibit 2, so I don't even know what your question was.
Okay, I'll repeat it.
Okay,
On Schwartz Exhibit 2, we've got medical expense itemization sheet. And the majority of the entries request Mr. Batchelor to pay 50% of the uninsured medical expenses. The last three, which are August 3rd, two entries for August 3rd, one for 183 and one for $25. And then one entry for August 17th of 2021, which is $154. Those three requests ask that Mr. Batchelor reimburse her 100% of the cost. And I want to know what the reason for that request is, because I didn't hear evidence of that. So Ms. Batchelor, if you can tell me what the discrepancy is there.
Yes, it's 100% because there was no insurance on him, on Brennan at that time. So that's what it says in our decree, that if he fails to have insurance for the boys, then he pays 100%. And that's what these three were.
So when did you get insurance on Molina, the Molina insurance?
It was about 2 months ago. But I don't have dental anyways, so I know at least two of these are dental.
can,
All
Your
right, so
Honor, I'm trying to find in where it states the 100% part. This is not
In the decree,
it's not really a ProDoc decree, so I'm looking for it. Never mind, Your Honor, I found it.
all right, any further questions after my question of Ms. Batchelor or Ms. Pierce?
You just asked why it was 100. Is that it, Your Honor? Okay. No.
Mr. Armstrong,
No questions for me, no.
Mr. Schwartz?
I have no further questions.
Okay. All right, I'll give each side just a brief closing. Ms. Pierce, you may proceed.
Thank you, Your Honor. Your Honor, this case could have been easily handled by the Attorney General at no cost to either of these parties. And due to Ms. Batchelor's decisions not to do that, it's cost my client not just the $6,300 in attorney's fees, but loss of a vehicle, almost losing his house, And he's suffered tremendously as a result of COVID. He wasn't fired. He wasn't terminated for cause. And she's been paid above guideline child support from April of 20 until May of 21, Your Honor, an entire 13 months of significantly above guideline child support. This is not the case of a man that didn't pay his child support. Evidence has shown that he's paid over $300,000 for these children, and because of the oil field, and at different times getting laid off due to the change of the oil field, he's gotten behind, but it's never because of willful unemployment and or intentional or by intentional design on his part. So I commend him for taking a maintenance job when that's all he could get and continuing to look for a better job. But I think that all of this could have been avoided by the parties just agreeing to the facts that they were on the ground. And so we're specifically requesting that she not be awarded attorney's fees, that my client be awarded attorney's fees, and that the court retroactively reduce his child support back to February 1 of 2020, because that's what he was making at that time. And Mr. Schwartz could have, well, he couldn't have, he could have moved to have the child support increased in July, but he chose not to. And so we're asking that the new child support amount based on his $5,000 monthly salary start December 1st of 2021, Your Honor.
Thank you, Ms. Pierce. Mr. Schwartz?
Yes, Your Honor. Ms. Pierce is requesting that people just go to the Attorney General without any legal representation and just have them solve the problems in a court hearing without having the benefit of the advice and the knowledge that a lawyer has. And that's not the way our legal system works. Our legal system works is that clients have their own representation and not go to a central authority. The fact that Ms. Pierce seems to think that this is just a rearage because of COVID. The sad fact of this is that Mr. Batchelor has been in default almost from the day after he got a divorce. The records reflect that in 18, he was $8,000 behind. This is in 18. This isn't in 2019, 2020. He has refused to obey the court orders. This matter there was a 2017 hearing. He admitted that he employed other lawyers to represent him. And his support pattern shows that he does not want to follow through with what the court orders. It was necessary for Ms. Batchelor to employ me to maintain that she have the support and make sure that whatever orders were entered concerning her support, that they would be according to the family code, the child support guidelines. Had she not employed me and just listened, she would not have had, she would have had to wait to get something done. The Attorney General's office has schedules that that can delay these matters. And so, and Mrs. Batchelor simply stated, all she wants is what the court has ordered. She's not asking for anything else. And she's entitled to have what the court orders. And she's entitled to have that determination made by due process to make sure that that no games are played by one party, and to make sure that the payments are on time, of which they weren't, and which is why we're here today. She doesn't want to incur legal expenses. All she wants, in order to get something she's not entitled to, here again, she stated that's all she wants is what's been ordered. Mr. Batchelor has admitted that he didn't pay those extra medical support payments because he thought, well, that I've already just paid that on that $100 on arrearage, and I'm not going to pay anymore. And we're talking about minimal amounts. We're not talking about big amounts. That speaks volumes about his attitude towards supporting his children. And the reductions were pretty well agreed to after Mrs. Batchelor obtained the services of a lawyer. So therefore, we're asked, Mrs. Batchelor is asking that the child support be along the guidelines of his earnings, which are $5,000. But here again, Mrs. Pierce and Mr. Batchelor didn't voluntarily agree that or inform the court that he also has a vehicle furnished to him, free of expense to him. He had car payments of about $800. So to me, it's just logical that the child support guidelines should be $5,000 plus the value of a vehicle, of which you could say it's pretty hard to buy any kind of a vehicle these days for more than $500-600 a month.
I believe he's trying to introduce evidence at this point. He's getting outside the scope of the evidence with his conjecture.
Overruled.
Also, he comes out with a $200 deduction from the $5,000, of which he doesn't know what that's for. He just says miscellaneous. So with our figures, based on $5,000 times 0.16, it's $655.31 and not the $625 figure. It's these little things that why counsel are necessary, because, for instance, that $200 deduction is not a valid deduction, and there ought to be a reasonable amount added to the $5,000 for the value of a car and gas. He admitted that he gets reimbursed for his gas, and that he uses his truck for personal and business reasons. So if you add 1,000 to 5,000 and do the 16% figure, you come to a child support figure of $767.87.
Your Honor,
Then-
I object that he's getting outside the scope of evidence in his argument.
Overruled is
and
this argument.
And Mrs. Batchelor also is not receiving any support for her 20-year-old son. Of course, the obligations of the family code end when the child reaches his majority or graduates from high school. But Miss Batchelor has raised these 4 children on her own and has had the problem of someone not paying the required child support. Just the fact, because he's paid over 300,000 for 11 years, there's 4 children involved here. And at one time he was making good money, and it's unfortunately he's not making it now, but the child support has been reduced. Now, and then he wants, and then he does not want to pay any dental, vision, or medical insurance. He's requesting Mrs. Batchelor to pay for that. If the court is not willing to put that complete burden on Mr. Batchelor, surely there should be some figure that would be fair to both of them, whether it be 50-50 or 30-70 in favor of Miss Batchelor. But the fact of the matter is, this is a child that it will be reaching 18 in his majority, and we're not talking but about maybe the end of this year and next year, which is will be approximately 18 months, but it's not going to extend beyond 2022. So it's only fair that Mr. Batchelor, if the court orders him not to pay any of the insurance, he certainly should pay some of the insurance and not put it all on Mrs. Batchelor. So, our argument is that the child support be over and above what they are requesting. And if we put a reasonable value for the value of the use of a vehicle and gas for a month, that's $1,000, which would increase the child support figure to be based upon 6,000 and not 4,800 as
I'm going to object
Mrs.
again, Your
Batchelor.
Honor. These aren't pled. He's outside the scope of the evidence, and he's trying to relitigate at this point.
I'm not outside the
Hold on,
evidence. The
hold on.
evidence was
Overruled. I'm going to allow what I'm considering a reasonable inference from, you had testimony about the truck and it and being provided by his company. So overruled. You may continue, sir.
in Your Honor. So we're asking that for nothing more than what the court has previously ordered as far as child support and medical, vision, dental, and health insurance. And the code allows me attorney fees to make sure that she gets what she's entitled to. And we're asking for the sum of, as pled in my exhibit, on attorney's fees. That's all I have, Your Honor.
All right, thank you, Mr. Schwartz. Ms. Armstrong?
Yes, Judge, briefly. As you heard from testimony and based on our petition, the Attorney General's office is requesting a modification and a confirmation of arrears. Parties already agreed to State's Exhibit 1, which showed what the balances are. If the court is going to start the new child support amount on December 1st, 2021, then I would ask the court to take a judgment against Mr. Batchelor for child support in the amount of $6,225.58 as of yesterday's date, November 9th, 2021, and a medical support judgment in the amount of $2,332.54 as of November 9th, 2021. As far as child support, Judge, I was able to calculate child
Hold on,
support.
hold on just 1 second. What was the requested amount on the medical?
Let me go back to that screen, Your Honor, I'm sorry. $2,332.54
Your
as
Honor,
of yesterday, November 9th, 2021. That's based on the pay record.
Your Honor, can I call in? I'm glitching and I'm missing what y'all are saying.
You may.
I'm sorry. I mean, I can hear y'all right now, but I'm scared it's going to do it again. I need to look up the 346 number.
I have it. If you're ready.
Is that by chance in your practice?
I said I
is it?
have it if you're ready.
You have what?
I have the
Oh,
number.
oh, oh, please, please, I'm sorry.
346-248-7799.
And I just put your code in?
Yes, ma'am.
Oh, gosh. Sorry, I did something wrong on my meeting ID. I left a 2 out. It says my participant ID. Oh, I'm in the meeting, it says. Okay. So, Your Honor, do I mute
It is.
my computer or?
You're probably going to need to mute your computer and use your phone for audio.
Okay, okay, sorry about that. Okay, now I'm here.
All right, Ms. Armstrong, you may continue.
Yes, thank you, Judge. I request the judge take those two separate judgments as of yesterday's date, November 9th, 2021, and set out a separate payout for each judgment. The child support interest, the payout needs to be at least $50 per more to cover interest. And the medical support judgment can be low as $25 per month, enough to cover interest, to start December 1st, 2021. Also, the state in our petition requested a modification. I did do child support calculations based on the testimony we heard during the trial. During the trial, Mr. Batchelor stated he made $5,000 monthly gross and has 2 other minor children in his care. Ms. Batchelor stated that the health insurance that she has for the one remaining minor child that they have together is $0. So I calculate child support to be $656 per month based on those facts. So that's the guideline amount for the court's reference. That's all I have down.
Would it be easier for me to set the judgments as of 10/31 rather than yesterday's date?
We can do 10/31, Your Honor. Let me give you those numbers. They're going to be slightly different.
I have them. I'm just making sure that I have them. So that's.
I'm
what I
okay
was-
with that as well.
Okay.
Yes, Judge.
All right. The court's ruling is as follows. Ms. Pierce, you'll draft. Entry is going to be same date I gave y'all on the other one, which is 11/19
November, okay.
at 9 a.m.
November 19th.
Yes, sir. And the court's ruling is as follows. The request for a retroactive decrease of Mr. Batchelor's child support from the date of service until the date of the temporary orders is granted. His child support is reduced to $463.39 effective February the 1st of 2021. What that means is that's a monthly reduction of, from his $1,500, it should be a monthly reduction of $1,036.61. And we're going to multiply that by 3 months, which gives us a total credit of $3,109.83. And applying that credit to the child support arrearage, the court finds that Ms. Batchelor is entitled to a child support arrears judgment in the sum of $2,974.69. And that's through October 31st of 2021. That child support arrears judgment is to be paid by Mr. Batchelor in the sum of $150 per month beginning December the 1st of 2021 and continuing on the first of each month thereafter until it's paid in full. Interest on that judgment will accumulate as it is set out in the statute.
Judge, I'm sorry, can you state the arrears amount again after the
The
credit?
The arrears amount I see, the child support judgment amount is $2,974.69. And what that is, Ms. Armstrong, is your child support arrearage through October 31st on State's Exhibit 1, less a reduction of $3,109.83, which was the 3 months of retroactive decrease I gave Mr. Batchelor.
Thank you, Judge.
The medical support arrearage, that judgment in favor of Ms. Batchelor is in the sum of $3,106.48. And that's through October 31st of 2021. Mr. Batchelor's order to pay the medical support arrearage judgment in the sum of $150 per month, beginning December the 1st of 2021. The court makes the following findings as it relates to child support. Court finds that Mr. Batchelor's gross monthly income is $5,000 per month. Applying the Attorney General's tax charts to that income, the court comes up with net resources of $4,101.88. I understand he put $200 for health insurance reduction, but the testimony was there is no cost right now on health insurance to Ms. Batchelor insuring the child. As the court did not give any reduction for the health insurance. The court shows that applying 16%, one child before the court, 2 other children that he owes an obligation to support, the child support of Mr. Batchelor beginning December the 1st of 2021 is going to be $656.30. And that will continue until further order of the court until the child emancipates.
Judge, would the court consider rounding that to the nearest whole dollar?
Yeah, I don't have any
The
problem with
parties
that.
agree?
$656, that's fine with the court. The child support is $656
Thank you,
per
sir.
month, beginning 12/1 of 2021. Mother is to continue to provide health insurance for the child. Obviously, this court would normally make Mr. Batchelor reimburse the entire cost of that up to 9% of his gross wages. But since I didn't hear any testimony as to what that cost is, and it sounds like it's zero right now, the court's not making any order for cash medical reimbursement for the cost of insuring the child. Uninsured medical expenses will continue to be split 50-50 between the parties. The request to increase the child support from July 1st of 2021 through today is denied. Typically, if someone doesn't pay their child support timely, this court awards attorney's fees. But also, typically, if I have a motion to modify and someone prevails and they're able to lower their child support, I give attorney's fees. So I'm in a situation here where I have issues with both sides. And I'm not real thrilled that dad just ignores his mail and the uninsured medical. He's behind, and he's behind on medical intentionally. He's just not picking up his mail and he's not paying 50% of the uninsured medical. But that being said, there's, some of this, he's overpaid quite a bit for a period of time that he couldn't get into court, and the court's factored all that in. The court is denying attorney's fees. Each side is going to be responsible for their own attorney's fees, and any other requested relief that I did not address is denied And that, the modification's granted. I don't think I said that, but the modification's granted and the court finds that all these rulings are in the child's best interest. And with that, anything further I need to address from any of the parties' lawyers before we go off the record? All right, thank you, lawyers. That completes the ruling of the court. We're going off the record.